Warren Court in America, I would go an extra mile to read a judgment. Sometimes we give the first draft and we publish that as a judgment. Even for my pleadings, I'll have a first draft. Reflect on it, have a second draft. And most of the pleadings have done well. It's actually the third draft, not even the second draft.
Yeah, in fact, the ones who have gone to magistrates, they've applied the same parity of reasoning as you said, even with respect to other offenses.
Yes.
Now, then the Weber case, which again has caused a lot of problems, including even what has been discussed here by some of the candidates, that good decision, but it did not provide clarity what happens to the cases already filed. And so, you know, and there are many of them that had been instituted. You know, the constituency you're referring to that I represent, many of them also even help litigants. They put in resources to file some of these cases, which they agree with clients, they will be compensated after the conclusion. Now the case has stuck. The Supreme Court has said that, you know, it's the director to deal with them, but without clarifying which, you know, the cutoff and all that. So, again, I don't know what is your view regarding that confusion. Again, whether, again, the Supreme Court should have gone further to put clarity so that, again, you know, that confusion does not arise.
Commissioner, the Weber case, I must disclose, I was the originator of it. I was instructed by the Law Society, as one of the things I've done for the Law Society, to nullify sections of that act. I appeared before Justice Ojwang, as he then was in the High Court. And he agreed that it had a lot of difficulties. As fate would have it, by the time it went to Supreme Court, I think I was out of the country, and another counsel was engaged. I have difficulties with the judgment, but maybe those difficulties arose because of the transition between counsel. But it's never too late. Yeah. Supreme Court is not bound by its decision, and at the earliest opportunity, Supreme Court, I'm sure, will look at it and bring clarity to the law.
Yeah, I see this because it has, it's one of the biggest matters that has caused a lot of pain and anguish amongst, you know, the lawyers.
Correct.
But the lawyers, I must say, were specific that they would want to hear your view regarding that.
Yes.
If you were to become, you know, our Chief Justice. But I hear you.
Yes. And they'll remember that I was there for them at the hour of need.
Yes.
Because at the hour of need, all lawyers who do accident claims, their practices had collapsed.
Absolutely.
So even getting interim orders from the High Court was a very big relief to the members that you represent.
Now, let me come now straight to the issue again of, to pursue that issue of perception, again, which has been raised by international, by ICJ, right? ICJ, they've raised this specifically, then I'm sure you are aware, you've seen what they've written.
Yes.
And they have been keen, you know, to hear your view on that, and also this Athletes Society of Kenya, so that you can be able to satisfy. And you know, one of the things that JSC did also was to put everybody's, apart from sample writings, also their biodata, everything, so that to be transparent. And now, and they say that, you know, they would want to hear, to have assurance regarding this issue of perception, because they believe that, you know, like some of them, you know, quoted the fact that even your church was commending you for bringing the president and the deputy president, you know, for a fundraiser in 2018. So they believe that you are quite close, you know, to the system. So I mean, to the president specifically and the deputy president. So I would still want to hear, and that's my last issue on that issue of perception, how you'll be able to deal with it vis-a-vis the issue of judicial independence, so that, you know, if JSC was to appoint, was to recommend you as the next Chief Justice, that Kenyans will not say that JSC had already decided anyway. It was just, you know, in social media, for us in social media, you will find many of them saying that everything else you are doing is just, you know, window dressing. The decision has already been made. In fact, there's even a joke that if you want to see the next, if you want to know who the next Chief Justice, scratch the card. Then they put your picture and they put, it's like it's predetermined, regardless of the merit and all that. So, as a last point, from where I sit, how do you deal with that perception, considering the fact that you are the chief agent of the presidential elections, which is not wrong. We are appointed in different capacities as lawyers, so one cannot fault for that. But we can't run away from the issue of the perception. And as JSC, we can't again run away from it because we are accountable to the public.
Correct.
Whatever decision we make, we must be able to stand and justify, that position. So I don't know what's your take regarding that.
Yes, I think, Commissioner, it's important I say this as clearly as I can. 2013, a great mark of honor, a great mark of trust to be entrusted with the petition. Together, of course, as you remember, I was a team leader. I had quite a number of advocates that I was working with. Let me say this, it was a one-off. In other words, after we finalized our work, I never continued working for HE, the president, in any other activity, personal or official, at all. And that ought to be put in the public domain as loudly and as clearly as possible. I was never a part or a member of Jubilee Party. Not that I have anything against the party, but because I prefer to be really a lawyer for everybody across the board. 2017, the same thing. It was a one-off. Regrettably, or as fate would have it, let me use the correct phraseology, as fate would have it, despite my walking into that court thinking this time, I'm very comfortable, the voter margin difference is 1.7 million, it was nullified. So I was engaged once again. One-off. And even after 2017, I retreated back to my private practice where I have continued working. I would wish and to emphasize to JSC and the Kenyan people that I'm here as a candidate of the people of Kenya. I am their candidate, and if given the honor to serve them, I will be appearing, so to speak, for the people of Kenya. Not segments of those people. I'll be appearing for the people of Kenya and I'll be implementing the Constitution. Commissioner, allow me to say this. It is correct. I do a lot of work for the Catholic Church. I'm a practicing Catholic. It is correct that indeed we are putting up a very big structure in honor of the founder of Consolata Missionaries. Professor Consolata Missionaries was founded by Blessed Aramano. Blessed Aramano, or his order, came to Kenya in 1902. Throughout the world, there is no country, and Consolata Missionaries are in very many parts of the world, where there is a building in honor of Blessed Aramano. But in Consolata Shrine, I, together with like-minded people, decided to have an office block in honor of Aramano. It's a big thing, and we are the first in the world. The construction cost is quite substantial. We raised it, but we are almost going on our knees. We decided to have a major harambe for all the people of Kenya, not for segments of the people in Kenya. So the first person I actually approached is our MP, Mheshimiwa Wanyonyi. And Mheshimiwa Wanyonyi actually came to church to say he will be part of us. It is also true, HE, being a Catholic, we invited him. It is also true that the deputy president, as the deputy to the president, we invited him. And we didn't just invite political leadership. We invited each and every person, mostly of the Catholic faith, but we also invited my friends who are of the Muslim faith, and very many other people. So in that congregation, political leaders were in the minority. The majority were people from everywhere, including one of the outreach is deep sea. Kenyans will call it a slum. I don't know why we use such terms. It's one of the areas we have in Westlands. Each one of them had turned out in large numbers, and we raised a lot of money. I'm saying this to emphasize one simple point. It is a mark of honor for a president to give a citizen, particularly a citizen who is not part of the government, some work to do. But it cannot be used against that citizen for any advancement in the career. And I say this with tremendous respect. If the president approached you as a medical doctor and you did a procedure for him, other patients will still see you as Dr. Macharia, not as the president's doctor, because you are not.
Yeah. Well, for me, I wouldn't mind to be his lawyer. You know, I don't want to lie. If he approached me as his lawyer, not now as JSC member, but before, I would happily do the work. Now, let me come now to your individual qualities. We just forget about these other issues. Singapore actually is a case that I admire, and I've also studied the Singapore experience a lot as CEO of one of the most successful banks. In fact, he also helped in setting up the investment corporation of Singapore. He was really renowned for that. And the judges themselves, 4 senior judges in Singapore judiciary, say that our problems are too big, we need an outsider. They agreed, we need an outsider. Just, you know, like yourself. The only difference, and that, I'm saying this because it's something that I put through to one of the candidates here. The only difference that they agreed that he needs a bit of judicial experience, and so the route they used was to put him first as a Supreme Court judge for a year actually, then became the Chief Justice. So which brings me now to the question, how you would relate that with you. If somebody said that, yes, because you are actually a jurisprudent, you are a walking, everybody agrees, nobody will argue with the fact that if you're talking about jurisprudence, it is in your head, you know, you are walking jurisprudence. But perhaps the best route would be Supreme Court first, then the Chief Justice to get the judicial experience because of the dynamics of the institution. I don't know what would be your response to that.
Commissioner, it could be said that of Singapore. It's not a rule of universal application. Let's look at my first employer, if we could, because it's a gentleman who made me who I am. From the time he left law school, and I think he was trained in America, then came here, did his bar exams, he was a prosecutor. He was a prosecutor for numerous years. When Charles Jonjo became the Minister for Justice and Constitutional Affairs, my boss was appointed the Attorney General. He didn't go through any formative training. And because of the leadership skills I referred to, he ended up being a fantastic Attorney General. So I don't think you require some incubation before you are given a role. And the same would hold true for Chief Justice Mutunga. And many other Chief Justices we've had in Kenya didn't have to go through some training period. I would say, without any fear, without any equivocation, that I have the tools, the ability, and most important, the zeal to transform the judiciary. I don't need to go through any other position, and that is why I didn't apply for the position of judge of the Supreme Court. Okay, if given an opportunity, just like my 2 predecessors, within 4 years, I should be able to come before you and come with my scorecard.
Now, again, Al Warren, who again I also respect, that's something we share. And I've also studied a little bit about his background, and which probably could also have influenced his success. But what I also noted is that, as you rightly said, between 1943, I think, up to 1953, that's when he was the governor of California. And California is slightly smaller than Kenya in terms of geographical spread. Because I think they're about 423,000 square kilometers. Kenya is about 580,000 square kilometers. So he was actually governing a country, so to speak, equivalent of Kenya. So would somebody probably say that by virtue of being a governor, where he's leading, he's in charge of a state, even in terms of the judicial processes in the state, the administrative processes, legislative processes. So he's garnering experience that goes outside beyond being an advocate or a lawyer, so to speak, that could probably have also influenced his success, that somebody maybe will criticize and say that perhaps he was better placed because of that background, that experience that goes beyond just being a lawyer, and that prepared him for being a Chief Justice. I don't know again how to be your answer, then I can leave that point.
Correct, Commissioner. Warren is a combination of many factors. He was a fantastic lawyer, went to become a governor, and then ended up as a Chief Justice. The candidate you're interviewing is not very different. I've just explained to you one of the things I did for University of Nairobi. And I didn't need to go to court to be able to transform that college to what it is today. And I've done many of such activities. Warren was in office as a governor, and what all these experiences give us is give us the experience to be outside what you do. If you just say, for example, and it's a poor example, you are sitting somewhere adjudicating day in, adjudicating day out, as you do in your chambers as an arbitrator, as compared to somebody with a better world view of beyond arbitration, who has the skills of the arbitrator, but has more than the arbitrator. That is what this candidate who is before you has. I am qualified as a lawyer, I'm qualified as a philosopher, I'm qualified as a leader. I am no different from Warren. I hope I am within near reach of my former teacher, Chief Justice Mutunga.
Okay. Then the other issue that I probably would want to hear from you, and I'm again picking it from the candidates who are here. Kenyans have been seeing the candidates. I'm sure even now they are watching you, and also they'll pick, a few points and all that. And now, it seems like some of them are also now asking, particularly now again the constituents that I represent, that you see, one of the most difficult periods for this country was the late 80s and early 90s, before the repealing of Section 2A of the Constitution, so the so-called Second Liberation. And many of us, for me, that's the time I was just coming from a university. It was a time when advocates, were out there, playing. In fact, I would say that time it's like the lawyers were the opposition. They were the ones who were advancing the human rights, bringing political change, and all that. So some would want to know that during that time, what role you played, in whatever way. It doesn't have to be even at the front, because people play different roles with the same objective and they realize the same results. It's the different parts that lead to the sum total that leads now to the change. That any role that you'd have played in terms of advancing the cause of the second liberation and bringing us to where we are today. Because as you can imagine, one of the qualities you're looking for in a Chief Justice is courage. I'm asking that in the context of courage. Somebody who would be able to be out there
I was just going through my searches around Moroateto. It is quoted with approval in Barbados. A whole paragraph of Moroateto is quoted with approval. Not just Moroateto, but a whole paragraph of how the Supreme Court came to arrive at a decision that a mandatory death penalty is an illegality. But having said so, I think I could say a word or two about it. In Moroateto, which I had occasion to argue, the question was not about death penalty as such. The question was about a colonial relic. In 1938, the colonial masters inserted Section 204 in the Penal Code. They did the same in other colonies, in Malawi, Zambia, Belize, a few other colonies. But at the turn of independence, those other countries had amended their law. But in Kenya, 40, 50 years later, we still have this Section 204. My attack was on a mandatory death penalty, not the question whether a death penalty is constitutionally viable. It could be viable. But a mandatory death penalty means that we are sharing our judicial power with the National Assembly. Judicial power cannot be shared. The unfortunate thing, commissioners, is this. I think Supreme Court didn't make it as explicit as it could that this applies only to Section 204. For the simple reason that Supreme Court thought you can bring into place other actors like Attorney General to come with proposals. Hopefully after they have come with proposals, then Supreme Court will give further directions. As fate would have it in this country, there is a word called lethargy, and after a year, the year that Supreme Court thought that the report would be there was no such report. I lost track with the Moroateto case. But I do know as a fact that what Supreme Court would have wanted to do was not done because the other players in that who are defined by name failed to do that which they were supposed to do.
And like I was watching this case of George Floyd, he was killed in May, I think, May last year. And now the jury is already now on deliberations. In less than a year, a determination will have been made, something that you're not able to achieve here. You've indicated about what will be able, to do regarding that. Now, backlog, that issue of backlog and the slow pace, which has an impact also on the economy and the livelihoods and all that. If you could just summarize just 3 steps that you take immediately to make sure that things can move. We can now move from talking now to the doing, because we must accept that everybody, before there has been a lot of talk on it to a point where it has become a tired subject. 3 practical steps that you take to ensure that you're able to take now the judiciary to the next level in terms of ICT, in terms of productivity. You've talked about the quality, also even because you talk so much about the quantity and you forget about the quality. Like now the backlog, we all know as lawyers that there are many judges who very quickly have these notices to show cause to dismiss, that they can show they've concluded, but they actually didn't conclude. So 3 practical steps that will be able to deal with the numerous challenges we are facing that are impacting on practice.
Commissioner, dismissal of cases for want of prosecution is not really an access to justice. It is simply a running away from the reality. So I want to deal with the lived reality of the litigant. The lived reality of the litigant is that he wants his case concluded. So let us take, for example, a division like civil division. We say 3,000 old cases. I would want to see, and I will deal with statistics, not hypothesis, how many cases have delayed over 3 years. There are so many. How many judges do we have? That is why I keep on saying all hands on deck. And maybe identify 3 judges, get them out of the course list, and we now dedicate ourselves to clearing the backlog. All this is a statistical approach. That is why the department dealing with statistics in judiciary, I would even want them to report to me directly. Deal with it from a statistical angle because that is a science. And see maybe 3 judges, allocate them nothing else, and these cases to be heard on a day-to-day basis. Current cases, because we must do both at the same time. You mentioned the case going on in Minneapolis. It's just an example of finesse. But that finesse comes because all the actors are working together. Not just the judiciary, it is all the actors working together. You saw, for example, how meticulous the prosecution was. It was witness to witness to witness, even when they were dealing with medical doctors and everybody. That is not an impossible thing for us to do. So that once we start a case, the magistrate or the judge can allocate that case a day-to-day hearing and complete it. And if we were to do those, plus of course, enhancing our IT capability, I assure you, Commissioner, within a short while, we will do what Singapore did. Because we are not inventing a new wheel. We don't even need to go to Singapore for benchmarking. We can see their statistics and their approaches, and day after my swearing in, we start rolling off.
Now, my last question is regarding accountability. Because human beings, they want responsibilities, but they don't want to be held to account. In fact, it's something I experienced when I was oversighting police, where the police would say that, you know, IPOA, you are interfering too much with our work. They do not want to be held to account. They just want the responsibility, no accountability. Now, again, judicial office, sometimes you'll hear some saying that they would not want, you're pushing us too hard. Give us the resources, give us the facilities, let us do the work, but you're pushing us too hard when it comes to issues of complaints. So now tell me, as our Chief Justice, what steps would you take to ensure that even as the resources, we are talking about resources, we are talking about facilitating the judicial officers, the judges, and of course even the judicial staff, that we are also able to hold them to account on behalf of the public, because public also, the complaints come from the public. They also want the institution to be held to account because it serves them. So would you also give us some kind of, very briefly tell us how you go about ensuring that you are also holding the people below you to account? In fact, starting from yourself as the Chief Justice, and then also the people who are below you, so that you are given that position, but you're also able to account to the public.
Commissioner, let me again cite a Chief Justice I'm starting to read quite a lot about, the South African Chief Justice. What he did, because in their JSC Act, equal to ours, it had certain lacunas, like what happens to delayed judgments. And he came up with what I think is a very innovative thing. He came with a practice note, or the equivalent of a practice note, to say that if a judgment is delayed more than 6 months, that is a reportable occurrence to JSC. It's reportable. Why am I going there? We are also coming from a culture where, as you know from your members, members complain of judgments being delayed for 5 years. That cannot be within the work ethic of the modern judiciary. With the tools that I proposed, that I would propose that were made available, if we have a case management system, and I saw this in the Arusha court, as soon as the court starts, the president of the court can be able to tell the court started at this time. So even the time you start your court, however far off you are, it is a reportable event. That way, you are able now to hold all judicial officers to account, that we are not just sitting back and saying we have independence, and the equivalent of the independence we have in mind is to do nothing, because that is not independence. Independence means or comes with responsibility. And that will not only be the judicial officers, it will also apply to the Supreme Court. We must also be accountable.
Okay. That's all. Thank you.
Thank you.
Thank you very much, Commissioner Jero. Thank you, Senior Counsel. I will now request the Attorney General to ask you questions.
Thank you very much, Madam Chair. Senior Counsel, good afternoon.
Good afternoon, Attorney General.
Just to follow up from the questions that have been posed to you, you're coming to a judiciary where, in the case of the Supreme Court, you have very experienced judges there, and that cuts across the board in the other superior courts, the magistracy, the qadis, and indeed the judiciary staff. And you have conceded, Senior Counsel, that you do not and have had no judicial experience. But you come to this interview with considerable and an illustrious career as a practitioner at the bar. How are you going to bridge this seeming gap of your lack of experience as a judicial officer, where you are expected to lead from the front, to give jurisprudential and administrative leadership to the judiciary, to the courts, and to the other people that you'll be dealing with, like the NCAJ and so on?
Attorney General, I do not see that absence at being a judicial officer as a gap in my CV. I don't see it. Mm-hmm. Just like I don't see it, the fact that you are never a state counsel with us and you being the Attorney General. I see leadership as the pivotal angle. I see in the Supreme Court, for example, judges who are never judicial officers. They became judicial officers when they became appointed judges of the Supreme Court. And they had no difficulty. And for them and for you, sir, you've been exemplary in your service delivery in your respective offices. The fact that I haven't been a judicial officer, but I've had a long exposure in law, and as you say, an illustrious career in law, I see, number one, I'll be easily accepted by the judges of the Supreme Court. I will actually be able to hold conferences with them from day one. I see myself being able to have a very collegial discussion with them. I have participated in most of their landmark decisions. They have, I know, some respect for me. For me, I have tremendous respect for them. So, number one, Attorney General, I see an immediate acceptance by judicial officers. And because of the way I have treated staff of the judiciary, I see no problem between the interface of I from private practice to be the Chief Justice. In other words, Attorney General, I see it as a very big plus. If I had been here and maybe quarreled in the nature of business with a judge, with so and so, that could even be a bigger concern. But because I've never been working here, I am, so to speak, a friend of all and acceptable by all. And with that, I say, without any fear, I see an immediate acceptance at the Supreme Court.
What tools are you going to engage in that leadership role in formulating your leadership style? What tools, what personal attributes are most important?
As I indicated, I would have prudential judgment, very, very prudential judgment. I'll learn where necessary. I'll have my cabinet, the Judiciary Advisory Council. I'll learn as quickly as I can. I'll be able to work with them, and to a large extent, I will be able to have very regular meetings with all of them and not change for the sake of changing. Try to work with the people that I find in office because they have my first point of call. And with the people in office would be really the way that I start my first, say, 100 days as I learn. Remembering at all times, Attorney General, that the buck stops at me. In Supreme Court, my leadership style will be very different, will not be any more different. I would want to understand the case backlog. I would want to understand how cases are, how benches are constituted, and then how we can start having our pre-hearing conferences immediately. Pre-hearing conferences, identify the issues, and get going. And in all those, I don't see any handicap. In all probability, I'll be the first to generate an opinion.
Thank you, Senior Counsel. You've just mentioned again the aspect of the expeditious disposal of cases. In the context of ongoing cases, not cases which have not been commenced. And my mind goes back to a case you will remember well because you were in it, of Goldenberg. You represented one of the accused persons.
Yes, I did.
And in that case, it was in the courts until virtually all the accused persons died. And even as we sit here, no judgment has ever been rendered. How will you deal with that aspect of the judiciary's current workload of cases which are stuck, part herds? You mentioned earlier when we were discussing the NCJ and how you would bring them on board, you used the word lethargy. And you're referring to the various players within the NCJ. How are you going to deal with that problem?
Attorney General, I don't know how far I can talk about this, but I think I'll be as guided as I can. You remember in the Goldenberg case, I once told the Chief Magistrate, let her remain nameless, that I think the prosecution strategy is to outlive all of us. And I made a pledge, they will not outlive me. This is because I think the prosecution strategy was never to conclude the case. So at NCAJ, because it's all closed door, I'll be able to discuss with the other players that if you're doing a case for only a PR exercise, look for another forum other than my judiciary. You see, there are cases that are made never to be heard. Can I say this without overdoing it? If you are to have 50 accused persons on 120 charges, each of the accused with one lawyer, that is not a case that is going to be concluded within the lifetime of an individual. But you can still achieve the success by breaking it down. Those are the kind of things, very frank discussions, as a Chief Justice that I'll have. Let's not use judiciary for PR exercises. Use judiciary services when you want a case heard and concluded. And for a case to be heard and concluded, our doors are open. And it's not for us to decide for them how to do their work. It is their constitutional right, but it's equally our constitutional right to say, please do not use us as the doormat so that you say judiciary is the one to blame. As you very rightly say, golden bug now is every accused person has died, and they died with that tag of having been accused persons. I shed tears when the last accused person died, because in all probability, there was no criminal culpability on the person that I have in mind.
Thank you, Senior Counsel. In the context of Article 160, how independent is the judiciary in your view, Senior Counsel?
Judiciary, and here I think we need to distinguish current and past. Past, I doubt whether it would have been said to be independent as an institution.
Let's deal with the current.
Current, I would say judiciary is fairly independent. I emphasize the word fairly independent because judiciary needs to do a little bit more. Is to show that independence, not just the decisional independence, but institutional independence. An Attorney General, let me quote this, let me say this. You see, the more our affairs are made public, the more that people see the case is being decided on merit, the more that somebody says that on their phone they can be able to see the progress of the case, the more we shall actually have 100% rating is very independent. I'll say this. The best antiseptic is sunshine. Sunshine becomes the best antiseptic. Let's open our affairs to the public, and that sunshine will actually show how independent we are. We are almost at the verge. Let's do the next 1 mile, and everybody will see this is a very independent judiciary. For decisional independence, I think that is something that I cannot comment. I would need to do a bit of empirical analysis, do a bit of review before I say what rating we are at. But I'll say, even for decisional independence, by and large, practitioners, and here I think Commissioner may agree with me, by and large, practitioners feel that the judiciary of today is very, very independent.
So, in that vein, Senior Counsel, as Chief Justice, as the President of the Supreme Court, and as Chair of the Judicial Service Commission, what would you do to bring about what you call fairly independent into the sunshine you have just described? What steps would you take?
Yes, I'll open judiciary to the sunshine, and the sunshine will come.
How will you?
Number one, we have better IT capacity, better case management systems. No files are disappearing because now they are digital. In South Africa, they have the files, the storage in court and another off-site, so that at no time would anything be said to be missing. And those are the steps, amongst others, that will bring the sunshine into the judiciary. We are just on the verge of that transition.
Thank you. Now, you've been in the corridors of the courts for 40 years. And if anybody can tell us whether there is corruption in the judiciary, it would have to be you, Senior Counsel. How would you respond to that?
It can be only me, Attorney General. The talk about corruption in the judiciary is at two levels. There's corruption at registry level, which to me is very insidious because it's there and you cannot see it. You know, Attorney General is a former practitioner as well, that will pay court fees and be given a receipt, only to realize that that was a dummy receipt. That money never went to judiciary. So one way of getting rid of that is using e-filing. By e-filing, you eliminate that type of corruption completely. And that, I think, has substantially been done. But having done that, you need audit system, periodic audit systems, so that there is no enterprising Kenyans getting into that sum of money. Then you come to the judicial officers. That is an area, that is the area that I think I would want to deal with as efficiently as possible. We do this really through a process of trying to inculcate ethical values, ethical virtues, and the more we do this, the more we'll get out of any perception of corruption. But needless to say, if there is any obvious case of corruption, not just obvious, if there is any case of corruption, we take it up as JSC.
But Senior Counsel, you're well aware, even when Chief Justice Emeritus William Otunga came on board, he worked very, very hard to deal with the issue of corruption even at the individual level. There have been commissions which have worked tirelessly and rendered reports and recommendations, and you are aware of them. The Judiciary Training Institute has offered training even on the ethical values that you speak about. How are you going to overcome this almost resistance that seems to be embedded within the judiciary?
The more we use the tools that I'm proposing, where you can see that a judicial officer went to court on this date at this time, did this case, and this is his decision, you are able to look at that decision with the necessary parameters and see whether it's within the law. That is one approach. The other approach is we can never give up on trying to inculcate the correct work ethics. Because the minute we start giving up, it is to give up on our own selves. So I'll still do as much as I can to try and inculcate the correct approaches to life, because it's those approaches that will bring us collective victory and collective success. So much as I know of all the efforts which have been done, including the commission you headed, Attorney General, including the interventions you had at the Court of Appeal, I will still not give up. I will soldier on, because this is a battle that must be won. Corruption cannot reign in judiciary. Corruption is a battle that must be conquered by the deliberate effort and the purposeful effort of the Chief Justice and the other members of the judiciary who the Chief Justice will be working with. It's not a one-man show, it is a collective effort.
Thank you. You spoke about the interdependence of the three arms of government. Would you consider the judiciary to be a threat to the other two arms of government?
Threat it could be, just like the other two arms could be a threat to judiciary. You can be a threat if you do not understand your constitutional mandate. If you understand your constitutional mandate, you cannot be a threat to the other arms of government. That is why, for example, it's a well-developed principle, which I would wish to even talk about at JTI, about judicial restraint. Judicial restraint is because we all understand the other actors in the economy have their own, for example, constitutional mandate to undertake. But of course, if there is conflict in how they undertake those mandates, it becomes a justiciable issue which then falls on us. So we can never be a threat if we restrict ourselves to the four corners of our constitutional mandate.
Could you elaborate on that and tell us how, as Chief Justice, you would seek to ensure that there is no undermining by the judiciary on the other two arms of government?
Is judicial overreach. And by judicial overreach, I mean matters which are not justiciable. We are not in the business of politics at all. That is not within us. But in politics, there may come an issue that is that is legal. For example, impeachment of a governor is a political process. But in that process, if there is any infraction of a legal right, then we take it up. But for the political process, we are averse to it. So, Attorney General, my view of the matter would be this: let every judge understand what is within our mandate, and that is quite easy. We have brilliant judges, and let's not have activism in judiciary, which can therefore mean that we start having unnecessary unnecessary attacks with the other arms of government.
But how would you do that, Senior Counsel, bearing in mind the independence of the individual judge? Where do you draw the line between what you've just called activism and independence of the judge?
Very well. I'll do this as JTI. That is our home. And in that home, we are able to talk about our businesses quite clearly. In that home, we shall be able to espouse what is our parameters. In that home, we'll be able to say what is now judicial overreach. Could I give an example? In South Africa, when former President Bashir went there, a High Court judge issued, as you may recall, an order to arrest him. And he followed it up the following day with a further order that he must be arrested. And Attorney General, I'm sure you will recall, the cabinet had to meet and reprimand judiciary for what they said you are now getting into very explosive areas of foreign policy. Those are the things that maybe with retrospect, one would have seen that these are matters which are not entirely justiciable. But that is something that, of course, within JTI, you are able, with your brothers and sisters, to be able to define parameters of what is justiciable and what is not justiciable.
Thank you. Finally, going back to the 41 judges. Chief Justice Emeritus David Maraga, I think, said that he had sought to engage the appointing authority in vain. He had made phone calls which remained unanswered. And earlier on you indicated that you would seek to dialogue. What happens, Senior Counsel, what will you do or would do in the event that your attempts to make those calls was also met with tomb-like silence?
I would want to see the two situations quite different, for the simple reason that situations can never be identical. And I'm not here to pass judgment on his style and my style. I do believe that as head of judiciary, there must be a way you're able to reach out to the Speaker of National Assembly, because he is a co-equal, or Speaker of the Senate, because we are all working for the people of Kenya. My approach is this. I'll approach it from Adam Smith. It's not benevolence you are looking for. It is an understanding that judiciary does not exist for itself. Judiciary exists for the people of Kenya. Approaching it from that principle, I do not see anybody not being unable to have a dialogue, because I am not doing this for self, but I'm doing it for the people of Kenya. Understood in that context, and since all the persons that we are talking about are, number one, patriots of the highest order, leaders of the highest order, I should be able to have a structured meeting with the three arms of government at any time. And I repeat once again, it's not benevolence, as Adam Smith in this book of Wealth of Nations says, but something for the common good of the people of Kenya.
I am grateful, Senior Counsel, for having answered those questions, and would have no more. Thank you very much. Thank you.
Thank you, Attorney General.
Thank you very much, Madam Chair.
Thank you very much, Honorable Attorney General. I will now request Commissioner Patrick Ishohi to ask his questions.
Thank you, Professor. Counsel, good afternoon.
Good afternoon, Commissioner.
Very good. I want us to focus on something different. You have spoken very eloquently about the judiciary, the Court of Appeal, the Supreme Court, and all those issues. I want us to focus in one key areas as you come in, if you get this position, and I pray you get it, as the chairperson of the commission. And I want us to remain on the commission itself.
This commission.
This commission. As soon as you get to the office, the first thing that you'll be able to get is a report by the consultants that was submitted to this commission, I think in 2019. In that report is about the review of the organization in terms of its operations. We are at the stage of implementation. As the chairperson of the commission, they have raised two issues that I would wish you to reflect on. One, governance efficiency of the commission is below average. Efficiency of the governance structure of the commission is below average. Two, weak performance management system, among others. That report will be on your desk if you get this position. Will you share with this commission how you address those two issues that are very prominent in that report by the consultants?
Commissioner, not being privy to what led to such low grades, because these are very low grades, not being privy to what happened for you to be below 50%, I may be a little hard-pressed to say what prescription I'll come up with. But I can say this. As a Chief Justice,
Chairman of the Commission,
and Chairman of the Commission, I will not only look at the report, because the report is the end product of a process. I will start off with where did we start doing things the wrong way. Because to have a grade that we are below average is an embarrassment to all of us. But there may be concerns and interventions that were not done at the right time. So I would want to see why didn't we do those interventions early enough? Why is our performance weak? I would want to see as many of those reasons as possible. And again, working with this commission, instead of us now saying how awful we have been rated, I will actually roll up my sleeves and say, look, ladies and gentlemen, we must get to over 90% at the next assessment.
Honorable Counsel, that's what I'm looking for. The instruments that you are going to put in place to take us to that level, as our leader, as a commission, as the chair of the commission, if you can be able to share with us one or two issues that you'll do to take us to that level of 90%.
That's what I indicated. I would want to know why we went to that low level first. That's the first port of call.
Yeah.
Because when you get a resort, Commissioner, a resort that is 40%, you may not be able to prescribe what is wrong without understanding what led to the 40%.
Okay.
So the first tool I'll look at is our history. When was the last assessment done? What has happened in the intervening period? And what is it that we didn't do correctly?
Okay.
Yes.
I think, Senior Counsel, what my colleague is looking for is hypothetical indicators. You know, I mean, if you are to assess, in your opinion, what would be assessed, even if it's hypothetical, you must have an idea of what would be assessed.
I see. I'll look at the leadership.
Leadership?
Leadership would be one of the things that I'll look at. I'll look at the collectivity. By collectivity, I mean, what are the other members' input or lack of input into that leadership? I'll look at the implementation. Those are some of the things that I'll be looking for.
Okay. I'm sure you have looked at the kind of structure we have the commission. And you're talking about the mechanism of making sure that the commission is accountable. Yeah, earlier on, you talked about accountability in terms of the members, in terms of the staff. I would like to hear from you, what mechanism will you put in place to ensure that the commission remains accountable in terms of the structures?
I'll put every measure in place. I will, number one, look at the regularity of the meetings, the agendas set out in the for the meetings, the way we transact our business, and more important, Commissioner, as you know, it is also the follow-up and the implementation of the decisions.
Okay.
So that if you have a weakness at any one of those levels, then you are not able to fulfill your constitutional mandate, which is set out in Article 160. It is 171. You know, you have a constitutional obligation.
Okay.
Yes.
Let's take the case of the staff. And you have to ensure that your staff remains motivated, productive, and efficient. We have human resource manual. We have policies that govern human resources. I would like to hear from you, as the chairperson of the commission, what programs you put in place to ensure that the staff are productive, efficient, and their performance measured?
Yes. One of the things I think in every large organization, not large, it's all organizations, is a bit, you've got to look at staff welfare.
The staff welfare, yes.
And there are certain very quick wins that you could have with staff welfare. Look at a medical scheme, for example.
It's in place.
Medical scheme for staff is one of the things that is very